Buckle up. Today we're diving into a courtroom disaster in the making. A defendant, facing jail time, boldly insists on representing himself in a probation violation hearing. The judge warns him straight up, no lawyer, no special treatment, and if he messes up, 6 months behind bars is on the table. But the guy doesn't blink. He signs the waiver with total confidence, ignoring the judge's "fool for a client" warning. It's the kind of slow-motion wreck you can't look away from. The paperwork is in, the stage is set, and the consequences are coming fast.
Yes, sir.
Okay, you're in court. Let me see what we got here. It's a motion to revoke probation has been filed in this case. You have the right to have an attorney represent you in this matter. If you can't afford to hire an attorney, I'll appoint one. Do you know what you're trying to do with regard to an attorney?
No attorney, sir.
Alrighty. Somebody give him a waiver form then.
But
You have the right to hire your own attorney. Like I said, if you can't afford to hire one, one will be appointed, no cost up front to you. If you choose to represent yourself, you have to follow the rules of evidence and procedure just as if you're an attorney. There's no special treatment. Are you under the influence of any alcohol or drugs right now?
no, sir.
Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. If you've reviewed the form and want to waive it and proceed today, representing yourself, you can sign it at this time.
Now the court lays out the battlefield. The judge calmly walks him through his rights, but this isn't some routine script. This is a legal roadmap for someone about to get steamrolled. The violations, unpaid fines, and no drug and alcohol evaluation. The defendant plays it off like he forgot the evaluation, a major red flag. This isn't a parking ticket hearing. It's a matter that could end with real jail time. And the more he speaks, the more you realize he doesn't grasp the weight of the situation. He's outmatched and walking straight into legal crossfire.
I'll find that you've knowingly, willingly waived your right to an attorney. I'll accept that waiver. I'll allow you to represent yourself. You understand you have the right to contest the allegations. Do you have a copy of the allegations, by the way?
No, sir. On the probation violation?
Yeah.
I believe it was for the remaining payment of the probation, because that was
Right. Also failed to provide proof of obtaining drug and alcohol evaluation. Those were the allegations.
to do which one?
We'll bring you.
The drug and alcohol evaluation?
Yes.
Okay. Alrighty. I did not do that unless I had done it with and sent it to Chris before, but yes, sir.
All right. Well, we're going to bring you a copy of those allegations here. All right. You understand? You have a copy of those in front of you, the affidavit alleging the violations?
No, it was the wrong paper. He's grabbing it right now. But I understand, sir. I do believe that I had forgotten to. The last time I talked with Chris, I do believe he had said that, and I had forgot about it and just thought it was payment.
Here come the excuses, and they're paper thin. He says his mom paid the fines, maybe last week, but there's no proof, and nobody in court has a record. It's murky at best. Then comes the real bombshell. He openly admits he never did the court-ordered evaluation. That's not just a misstep. It's the kind of blatant non-compliance that judges don't overlook. This isn't about whether he's a bad person. It's about whether he followed the rules of his deal. And right now, the answer is clearly no. You can feel the judge's patience thinning with every word.
In probation at a hearing in an open court, it's the state's burden to establish a violation by a preponderance of the evidence. You have the right to present testimony of witnesses and other evidence on your behalf if you want to. If a probation violation is established or admitted to by you, I can continue, extend, modify.
The courtroom cuts to the chase. The judge brushes aside the confusion over fines, not because it's irrelevant, but because the more serious failure is clear: no drug evaluation. The judge accepts the defendant's admission and officially moves toward ruling. The moment feels cold, clinical, but also fair. He's giving the guy rope, and unfortunately, the guy's tying his own noose. What started as a minor chance to clean up is now unraveling quickly. And it's clear the judge has shifted from helpful to resolute. The hearing just crossed a point of no return.
Revoke your probation. I could require you to serve the underlying sentence. You understand all the possible consequences?
Yes, sir.
Do you understand all your rights as I've explained them?
Yes, sir.
All right. It's alleged that you failed to make payments as required on your court costs, fines, as ordered by the court, and that your last payment was back on November 5th of 2021, and now you have still have a balance of $418. To that allegation, do you admit or deny?
That I paid that up in full. Whenever I paid that, I believe it was this last week or the week before, and then scheduled for the court date for today.
Is it paid up?
The prior, I had made made arrangements. My mom had come over and to the court and paid everything remaining because I had moved down to South Texas, and then but they had added more charges, and then but the drug evaluation part, that I had forgotten all about that. But I mean, there's no record of like I have not been in trouble, or you know what I mean.
Your mom paid off your fines or whatever. It's paid off.
Well, and originally she had come up here to pay them. She paid everything they had on file, and then they had added that last $418 after she had come here to pay.
So the balance is $418 still. Is that correct?
No, that was paid last week or the week before.
Can somebody just go look?
We don't know.
We have no way of looking now. So let's skip that because
She said if it went to collections and he paid collections, we haven't been able to get it from them.
it may have went to collections. Let's just skip over to the next one. It's alleged you failed to provide proof of obtaining a drug and alcohol evaluation as ordered by the court. To that allegation, do you admit or deny?
I admit I did not do that.
Okay. I'll find that you, Mr. Marcinski, right now the court has no way of checking into any of this. I think it's been sent to collections is what I'm being told. So they don't know what's been paid, what hasn't been paid.
And if he has a receipt. Yeah.
Yeah. Okay. Are you fine with skipping over the payment, Mr. Marcinski, at this point?
Well,
I'm not going to have a way of finding on it one way or another anyway, Miss, what I'm telling you. Nobody knows.
It appears to me that he is stipulating as of the date of this affidavit, he had not paid it. So the fact that he paid it 2 days ago or a week ago doesn't alleviate the fact that he committed this violation.
Well, that's okay.
I'm not going to contest that he hasn't paid as of today, but it would seem to me that as of the time of this PV affidavit, that amount was
It's all academic. I don't put people in jail for not paying their fines usually anyways.
The judge gives him one last shot to speak, and it's a train wreck. He stumbles through a half-hearted apology, brings up an old injury, and tries to justify not traveling to Kansas. There's no strategy, no request for mercy, just a muddled monologue. He even offers to do the evaluation now, but it's far too late. He had years. The judge doesn't yell, doesn't argue. He simply drops the ruling. Probation revoked, sentence to be served. It's swift and final. The gavel doesn't drop, but the silence after his ruling hits just as hard. It's over.
Your rights. I'll accept your stipulation as to the second violation. I'll take the first one under advisement until stuff can be sorted out. I'm just not going to get into that right now. It's not really necessary. State's recommendation.
Judge, I may defer to Chris on this one. Looking at my file, we're a little light. All I see in here, my last notes in this file were when I offered Mr. Leesman a plea from the felonies that Kerwin had charged him with to a misdemeanor. The very next thing I have is the PV affidavit, and then my most recent document in the file shows a no bond warrant for his arrest. So obviously that at some point was lifted because he's bonded out and sitting in front of us.
I don't think so. I think he had us put on the docket and showed up. I think the warrant's still outstanding is what I'm told.
Okay.
As far as we know.
So I would probably ask Chris what he thinks is appropriate. At this point, if the case is paid in full, you know, my primary cause for doing what I do is to try to get these folks into drug and alcohol treatment to help them get over their addictions. And it sounds like even as of today, that hasn't occurred in this particular case. And I see now that 3 years, almost 4 years later, I don't know what the benefit of that is, but there has to be some consequence to the violation. I mean, pretty much just disregarding of the probation. So I think at this point, Your Honor, I would probably request a sanction and then for the case to be terminated if it has indeed been paid in full, which I'm not contesting based on his statement that it has been paid. I would also ask the court to maybe ask Chris Hollis what he thinks is appropriate, at least as far as the sanction, and he may be able to even educate us about the payments and other things.
Your Honor, Mr. Leisman was on probation for almost a year, and he was on call-in reporting because he was a resident of Texas. Last time I spoke with him was on February 8th of 2022, and I informed him that he needed to come to Kansas so he can sign an extension of his probation due to the fact that he had not completed his drug and alcohol evaluation, and he didn't make, well, he still had an outstanding balance of $418. He told me that he's not going to make the time to come to Kansas, and that if I need to file an affidavit, then just go ahead and do it. And then, of course, we haven't heard from him in over a year, almost 2 years. So my recommendation is that his probation is revoked.
All right. Mr.
And
Leisman.
when he did call in, Your Honor,
Okay.
it was very sporadic. He would miss call-in reporting. I'd have to call him.
Reality comes crashing in. The defendant finally asks, "How long do I have?" The answer? 6 full months. His voice shifts, confused, maybe desperate, but the judge gives him nothing. It's done. No more chances, no more paperwork. This is the moment where self-representation costs him everything. The entire hearing is a cautionary tale about what happens when you think confidence replaces preparation. He didn't just lose a hearing, he lost his freedom.
I apologize for the forgetting of that. I'd gotten in another accident right around that time before. It was October it was October before that February. I had talked to him, so I'd been healing up, and I'd forgotten about that drug and alcohol evaluation. And whenever we had talked, I had asked, he said I had to be here tomorrow to sign the paper. And I was asking, because I couldn't come from Port Aransas at that time all the way to Kansas to sign a paper. And I was seeing if we could do it like over like fax or, over like e-documents. So I didn't have to come in person all the way to Kansas to extend it for me to go do that drug and alcohol evaluation. But I do apologize for forgetting about that part. And I could get one done as like today, as soon as we leave here. I just wanted to get this warrant taken care of, but I understand. So
Productive Member Society. I think the only way you can do that right now is that you become sort of deterrence and encouragement for other people to follow the orders of probation. So I'm going to revoke and remand you to serve your sentence. Good luck.
Wait, sir, how long is it? I came up here from, I came up from Texas all right, sir. All right. How long do I have to do?
Whatever the original sentence was. I think we went over that, didn't we?
The original sentence was 6 months. I don't know if he's got any credit for time served on that.
Yeah, that's what it is. 6 months.
Or it was for a misdemeanor. I still have to do 6 months?
Yes, sir.
All right, sir. Okay. Is there any way to like that?
It's
never mind.
time to face the consequences. That's what's happening. State versus Colton Marceau, 23 CR 300025.
Yes, sir. Can you grab my phone right there, sir?
Sure.